Welcome back to the Trials Podcast. This is part 2 of our conversation with trial lawyer Lee Gresham. In this episode, we dive specifically into birth injury cases, what families need to know, the challenges involved, and what to do if you think you have a case.
Now, Lee, let's circle back to the birth injury cases. I guess the most extreme would be death, unfortunately, but what are some of the other injuries that people should be aware of that are associated with, problems, with birth injury cases?
I think one of the biggest is a hypoxic brain injury, where the child is without oxygen for some amount of time. There are varying degrees of injury in such a case. The severity can be associated, and is usually associated with the length of time that the child was without oxygen. I have a case right now where there's a brain injury involved, and she has cerebral palsy and is disabled, completely from a physical and mental standpoint. And we think that she was without oxygen in utero for at least 20 minutes, if not longer, and then thereafter, before they were able to resuscitate her, for another 15 or 20 minutes. So she was without oxygen for quite a while. Thankfully, they were able to resuscitate her, but she is very much disabled as a result, and that is not an uncommon thing. We attribute that to several breakdowns. The nurse had a responsibility, the doctor had a responsibility. There were things that they could have done and should have done. We maintain that they should have intervened earlier than allowing the child to be delivered vaginally. So that's an example of another type injury.
And I guess the heart of that case is the baby should have been delivered sooner by C-section. That
was an option. Yes, they could have if they had intervened in a number of different ways. I think there could have been a different result. But ultimately, yes, if they had gone in and gotten the baby earlier, we likely would have had a very different result.
Well, and so, Lee, that kind of brings me to maybe just as a practical matter, oftentimes people think, well, mistakes happen. What is a lawsuit? We don't want to talk to an attorney. We're not about filing lawsuits. Mistakes happen. And if you could, I'd like for you to kind of, specific to birth injury or any other type of medical cases, could you talk with us in some practical terms about what's at the heart? I know you've done a great job of giving us a legal overview of the legal standards, but from a factual standpoint, what are what are some of the, just practical facts that you've seen in cases over the years that in my mind, from my perspective, would kind of answer that question? What's the point? To a family that is dealing with this and they're thinking, how many times have you heard that we're not the type of people to file lawsuits or hire attorneys, but what is at the heart of these cases? From a factual standpoint, what are you seeing that went wrong, and then what do you have to prove factually?
I think the two most common things that go wrong, so to speak, are inattention to what's going on, or not being qualified to know what's going distress case that I just described that I'm involved in, I think we had both. I think there was an inattention to what was going on, reading the fetal monitoring strips, what was going on in utero with that child. There's evidence that that child was struggling to survive, struggling to thrive. You can see it in the monitor, in the strips. I think both the nurse and the doctor, curiously in that case, they never thought there was anything to be alarmed about. And then this child is born with no heart rate, no respiration, and had been that way for some time in utero. So I think those are the two main things. And I think there's several things that we have to prove in a perfect case. You would be able to show that the child was healthy in utero when she went to the hospital to deliver. That's the first thing. The second thing is that the fetal monitoring strips go from normal and reassuring to ominous and non-reassuring. That's number two. And then the third thing is that the healthcare providers had the opportunity to do something about it, and they didn't. And that's they didn't do something because they didn't know to do something, or they just weren't aware of it because they weren't paying attention.
And as the plaintiff lawyer, law firm, this has to be proven by qualified medical testimony, qualified medical experts.
Yes. The breach in that case would be you'd have the OB doctor testifying about the breach of the standard of care of the OB who was delivering the baby or to deliver the baby. And then you would have a labor and delivery nurse who testifies as to the nurse's responsibility, what she should have seen, what she should have done. She should have alerted the doctor. She should have put in an internal monitor. There were things she could have done to alert the doctor and change the outcome. And then, the other experts that I mentioned follow those two, but they're the primary breach of the standard of care experts involved in the case.
Well, Lee, right now in talking, is there anything else about medical cases or specifically birth injury cases that you would like people to know?
Yes, I think two things. Number one, I don't want to paint a gloom and doom picture of medical malpractice cases. They can be won. You can prevail in these cases. They're difficult, but you can prevail in them. Number two, as it pertains to birth injury cases, I think birth injury cases may be some of the strongest medical malpractice cases, depending on the facts, obviously, that you can have. And I also think they are cases that you're being the voice of that child, whether that child survived and is disabled or the child did not survive. You're the voice of that unborn child. The medical personnel are there to be to bring that child into the world safely and healthy. If they didn't do that, then the only thing you can do is try to seek accountability through litigation. And I believe in these cases. I think that it's a noble fight. It's not, no one's trying to smear the name of the doctor or the nurse, but we are trying to hold them accountable for this child is now horrifically disabled as a result of your negligence. And we believe that you should be held accountable for that.
Well, and Lee, you and I have firsthand been with families, and we see how stressful these cases can be on a family. Again, I go back to television and media. Oftentimes, we'll wrap everything up and put a bow around it in a 1 or 2 hour program. But realistically, what kind of timeline are we talking about in litigating a medical case?
Well, I get fairly cynical when I talk in terms of how long does it take, because a lot of times there is delay on the part of defense counsel, not necessarily the defendants themselves, but defense lawyers have they want to build their file. That's what they're trying to do. So they have no interest in trying to resolve a case early. The longer it goes, the better it is for them, the lawyers. But all that said, I think you can expect with our legal system the way that it is today, and which includes having to deal with other lawyers. These cases take 18 months to 2 years usually. They take that long. Sometimes they take longer than that for a myriad of reasons. But one of the biggest issues is getting experts deposed, taking their depositions, and it is very difficult when you're talking about all of the experts are doctors or nurses, so they're very busy. It's difficult to schedule them. Like I said before, if I have 4 experts, they have 6 or 8. So you're just talking about taking expert depositions all over the country, which is time consuming and also expensive. So I would say 18 months is optimistic, but 2 years is more likely.
Well, and Lee, I know in particular a case that you and I are involved in. I believe you've shared with me that there may be 50 or more witnesses called for trial. And so often, wouldn't you say that it's not uncommon for a mother, a family, to contact us a year or more after an event? Then this case in particular was during the COVID, so there were delays there, and of course other scheduling delays when you're dealing with 25 to 50 witnesses, give or take. And we've seen firsthand what kind of toll. Is this typically something that a family wants to engage in, and what kind of toll does it take on them oftentimes?
Well, the main toll is time, but as far as being involved in the day-to-day, we try to limit that to, we obviously have to have contact with our clients and cooperation with them to answer discovery and also to have their depositions taken. But, I usually tell my clients, after your deposition is taken, we're going to leave you alone. It becomes an expert case then. And so there's not a lot of day-to-day burden or toll on the family, but there is the unresolved issue. And I've seen time and time again where affected families want closure. They want the end of the lawsuit. The money is aside. That's beside the point to a lot of families. They want closure and they want to be heard. They want their day in court, and whatever that looks like. And so, the toll is can be managed from a direct contact, in the client's involvement. But you can't ever minimize the toll that it takes on them emotionally, just as with the case dragging out.
Well, and Lee, you've spoken with us today, talked with us about the cost and the risk involved. What does a medical case cost a family or cost a mother that's in this situation?
Well, typically, plaintiffs' firms like mine, like yours, we work on a contingency fee, which means that we only recover if we recover on the client's behalf. If we take a medical malpractice case and have $100,000 in expenses, we go to trial and we lose the trial. The client doesn't owe us a dime. We take on all of that burden. So, hopefully, I think that's pretty much across the board as far as plaintiff law firms are concerned. They'll take cases on a contingency fee, which really is the only way that most people would have access to the court system. They wouldn't be able to afford it otherwise if they had to pay somebody to work hourly.
Now, Lee, I know you've touched on this briefly, but if you would share with us, again, we talk about the challenges the injured face. Could you talk with us and maybe anchor this down with a few case examples, maybe your most challenging case, your most rewarding case.
Well, you're putting me on the spot with those, but um, I've got a case right now that has languished. It's gone on longer than it should. The my client has a severe permanent injury as a result of a surgery that was performed, and you know it's hard to see her suffer, and it's not any of our doing as far as the case languishing. The circumstances are what they are, but that's a case where I really feel for my client. I'm I'm sympathetic with all of my clients, but I really feel for this client because this is there's the emotional component that I spoke of, as well as the physical and the financial component. As far as I can't think of a specific case off the top of my head that would be my favorite case or whatever to think of, but I can think generally of cases where when we resolve the case and it's to our favor, and the clients are so gratified by really it's not, and you don't ever hear them talk about the money. It's that you would take on my case and represent me. And I think that's something that lawyers, we all have to remember. We're standing in the shoes of these clients. And, we owe it to them to give them the best representation that, we can give them. And so that's the most gratifying thing to me when that's the best case to me when a client is appreciative of my representation. You represented me well. That is everything to me.
Yeah, and lead it to take that a step further. Oftentimes people don't see everything that goes on behind the scenes, the workup of the case. Wonderful. We go back and we started off talking about, or at least I started off talking about my dad telling me to get a good education and help people. Son, that's something that nobody can take from you. And a lawyer, a wonderful trial lawyer that comes to mind here in Dothan, Randy Smith, that I had the opportunity to work cases with. Randy would always say, Aaron, we don't win our case at trial, we win during trial preparation. And oftentimes people may have a misconception, or the time that it takes, the scheduling of everything, and think that nothing's going on, not realizing all the work to work the case up for trial, to prove your case, all the strategy, and sometimes how razor thin all of that can be to kind of work it and put it all together. And it really is meaningful when you develop that partnership with somebody. And that's one of the things that I think part of what you're saying there, when we take these cases on as a contingency fee and that relationships form there, it really is somewhat of a partnership. We're all kind of working together to prove that case, and it really is gratifying when somebody recognizes that and you're able to to put that all together and bring it to a resolution. And it's even better when they're happy about it, because um, we call it the justice system, but you and I know it doesn't always work that way. Oftentimes we're looking at the best result or the best outcome possible that may or may not be the most fair or most just, but sometimes it does all line up that way. Just to take that challenging and rewarding. Could you talk with us about, as we get closer to the end here, could you talk to us about specifically the challenges that you see your clients facing, and how you deal with that, and then the challenges that you face in representing the injured, and how you deal with those challenges?
I think the biggest challenge, I think they're very connected. The biggest challenge for the client, the biggest challenge for me or anyone representing individuals. The biggest challenge for the individual, I believe, is not knowing what's going on, not really understanding the process, thinking that nothing's happening in the lawsuit, and they just want to know. I mean, I got an email from a client just last week saying, "Can you give me an update on the case?" And I gave him a short paragraph, 3 bullet points. I took the depositions of so and so and so and so. I filed this motion. I did that. I gave him 3 things, and his email back to me was like, I just sent him $1 million.
It makes all the difference.
Makes all the difference. So I think the challenge for the client is not knowing what's going on. The challenge for the lawyer is to keep the client informed.
Yes.
And that's communication, and it's the hardest thing. Most lawyers, it's, if you ask them what's the hardest thing that you do, and it's like communicating with my clients. It's time consuming, but it's a necessity. We have to do it, and it builds trust with our clients. It builds a relationship where they know that we're doing what we told them that we would do, and we owe it to them. We're their representative, and we need to let them know. And I'm preaching to myself as well, because it's a hard thing to do, but thankfully I have a paralegal that makes me do it.
Yeah, that does really make all the difference in the world, and it can be challenging at times because you and I live in a world in the trial law, injury law. We can get on the phone or text or email, and we're speaking the same language, and it's not at all that our clients sometimes don't understand, but just there's not the decades of experience there in working these cases and understanding how it all comes together. So it can be a challenge but it does make all the difference in the world to give them those periodic updates and to kind of help strengthen that bond and the partnership. And and often, and most of the time, if not all the time, that's just going to make the case go better for everybody. Lee, as we begin to wrap things up here, I'd like for you to talk to us about some takeaways for people that think they have a medical case, or specifically a birth injury case. So often we have a tendency after a tragedy, and it's completely understandable, we'll deal with that later. Right now we've got to take care of what's, in front of us right now. We'll deal with the legal, or we'll talk to somebody. And that's one of the themes that one of the themes that I've seen in medical cases is so often making a phone call to an attorney or to an injury lawyer is not the first thought of a mother or a family. And what I've seen is it may be a year into it, give or take, somebody close to the family, somebody trusted, will say, call Aaron, call Lee. You need to talk to somebody about this. So, one, is that the right approach to take, and what takeaways do you have in relationship to that, and any other takeaways or things that you would want a family to know?
Well, obviously, we would like to get involved as early as possible after the incident itself. For families, if there's and I hate to even say this because it sounds so callous, but if there is a bad result, whatever that is, in terms of a birth. If there's any injury involved, or death, then whether you think there's something there that breached the standard of care or not, you should get a lawyer to look at it, because that's a really bad, that's a life-changing event, and you really want to be informed as to is this something that I should pursue legally or not.
And Lee, what is it going to cost a family for us to review in that situation?
Yeah, there's no cost involved ever. There's no out of pocket ever. You contact a plaintiff lawyer, and he or she will likely get you, the family, to gather the medical records, and then the lawyer will review them and give you an opinion as to whether they believe this is a case or not. And there's no charge for that.
Well, and Lee, I can think of a case in particular where we spoke to a family. They got some records together for us. You got a pathologist involved to do an autopsy, and the cause of death was not linked. And like you said, it was one of those hard conversations with the family, but you didn't send the family a bill for that autopsy.
Right, yeah. I remember that clearly. That autopsy took 8 months. It took us
Yes.
eight months to get that autopsy, and I think it wasn't cheap, and that's just the cost of doing business. If the result had been different, then it would have been likely a great case, but it wasn't, and that's part of the risk that I talked about it a little while ago when we started. But that's just what you have to do, and sometimes, and thankfully, that doesn't happen. That would be a bad business model if that happened all the time.
That's right.
Thankfully, that doesn't happen.
Well, Lee, are there any other takeaways that you'd want people to know, or anything else in relationship to medical malpractice or birth, and specifically birth injury cases?
Yeah, I think just be alert. Families, people who are injured, due to what they think might be medical negligence, and then as far as lawyers are concerned, also be alert. And if that's not your specialty, then send it to someone who specializes in medical malpractice cases. For instance, I just got a call from a guy who's a probate lawyer. He doesn't know anything about medical malpractice cases, but he knew there was a bad injury, and so he put the client in touch with me, and we go from there. So I would just say be alert from both the individual and lawyers in terms of potential cases.
Well, Lee, I really appreciate you being here today. I can't thank you enough, and I want to reiterate how much we appreciate our friendship with you and what you do for us, what you do for our clients, and I look forward to continuing to work with you.
Well, same here, Aaron. It's been my privilege to be here. I appreciate you having me, and I've enjoyed it, and look forward to. I don't have as many years left as you do, but as many years as I have left, I look forward to being your friend and working together with you.
Absolutely. Thank you, Lee.
Thank you.
Thank you so much for listening to the Trials Podcast. If you or someone you know has experienced a birth injury or medical malpractice, don't wait. Reach out to our team today for a free consultation. There's no cost, no obligation, and no risk to you. Visit our website or give us a call. We're here to help you understand your rights and fight for the justice you deserve. Until next time, stay informed and remember, you don't have to face this alone.